Welcome to Pretty Lies and Alibis. Let's seek the truth and travel the long road to justice together. What you know, Alibis, welcome to another episode of Pretty Lies and Alibis. I'm Gigi. Good to have you here. It's Friday. We made it to the weekend. Hope you guys have something fun planned or just relaxing, or maybe you have to work, whatever. I hope you have a good one. We're going to jump into part 2 of reading this filing where George Wagner wants a new trial. But first, you know the drill. If you're watching on YouTube, don't forget to hit subscribe if you haven't already. Like the video, share it with your friends, and you can ring my bell if you want notifications of when I post new content. Click that little bell icon. Music fact of the day. Olivia Newton-John's song Physical was the longest running at the top of the Billboard Hot 100 charts during the 1980s, y'all. My little 9-year-old self ran around singing that song, not knowing the meaning. I also got in trouble at church once for singing Grease Lightning in Sunday school. Had no clue what those lyrics meant either, but now I do. We're going to pick up on the filing where we left off yesterday. The last thing we talked about was the emotional victim impact testimony and how the appeal filing points that out as something that could have swayed jurors in their deliberations. And we picked back up with the same topic. They mentioned Hannah Mae's boyfriend, Corey Holdren, offering testimony about how wonderful their relationship was, how great of a mom Hannah Mae was, and their last text message conveyed their love for one another. He also said Hannah Mae was a hard worker like her mom. He heard from Kendra Roden that something bad had happened, and he rushed over to Hannah Mae's house. He said when he found out she had been killed, he froze and sat in the grass until authorities pushed the growing group away from the crime scenes. Samantha Staley, someone who had dated Frankie in the past, she testified that she lost control of her emotions and had to call her husband to come home ASAP, saying that something really bad had happened. She said even though she and Frankie broke up a while back, he was the first boy she actually loved, and all of that was a lot of trauma at one time. The filing said that evidence without any real relevance was also admitted to pull at the jurors' heartstrings. They mentioned that chalk drawing in Dana's garage, and on the wall it said that Dana loves Chris and we love you. The photo was admitted to show the distance from her garage to the house, but George's attorneys say that's an irrelevant fact. The state also admitted in photos of Hannah Mae's newborn's diaper that she was found in after the murders, which obviously was soaked with blood. During the trial, the state actually asked for a break in the middle of testimony to get the bloody diaper from the evidence room. They say it wasn't needed, and it undermined the fairness of the trial. The state will likely argue that George did not object each and every time the jurors saw an exhibit that was admitted. But from the very beginning, George objected that it would be prejudicial to project photographs of the deceased victims on the TV screens that had been made available in court. If this court somehow finds that any error in the admission of any particular testimony or exhibit raised by this assignment of error has been forfeited, George asked this court to notice plain error. The problems with gruesome evidence and victim impact testimony were obvious and heavily litigated throughout trial as numerous objections were raised. There is a great probability that the jurors, including those who knew Chris Sr., Dana, Frankie, Hannah Mae, and little Chris, were unfairly swayed during deliberations. This was a manifest injustice. Another point they bring up, the trial court erred and abused its discretion by admitting evidence of other acts, wrongs, and crimes throughout the trial, which unfairly prejudiced George. The rule is simple. Evidence of other acts is admissible when the evidence is probative of a separate non-propensity-based issue. This rule is typically utilized when a proponent of evidence seeks to establish the identity of an offender by tying together similar specific instances of criminal or other bad conduct. Courts must closely scrutinize the proponent's logic to determine exactly how the evidence connects to a proper purpose. The state went overboard with evidence of weaponry unrelated to the murders. It did not add much to the dispute over George's credibility, and the trial court's cautionary instruction would only have confused the jury. Throughout the trial, George objected to physical, photographic, and documentary evidence of guns that had nothing to do with the crimes charged in the indictment, including 16 actual guns and dozens, if not hundreds, of shell casings that were admitted. None of these were used to kill anyone. The state claimed a need to demonstrate which guns were available for Jake to modify with a silencer, and it wanted to call in doubt a single statement George made on a wiretap recording that a gun list found on Jake's phone was a wish list rather than an actual list of guns owned by his relatives. Even if there were probative value to such evidence, this court should still reverse and remand for a new trial because evidence of unrelated weapons that have been withdrawn or ordered excluded, including 5 guns, went to the jury. Giving unadmitted evidence to jurors is a reversible error if prejudicial. The Ohio Supreme Court has noted the consensus of authorities that have recognized the introduction of other weapons evidence, irrelevant evidence of weapons unrelated to the charges, as error. Such evidence is presumptively harmful error because the danger is the jury will consider the accused bad character or propensity to crime as an evidence of guilt. The evidence of the defendant's involvement in a charged crime was circumstantial, without corroborating, probative, scientific, or forensic evidence to connect him to it. The state will likely argue there was no prejudice to the jury's deliberations because a cautionary instruction was given. But this court has observed that with the presumption such an instruction will be followed can be rebutted by showing that the evidence could not have been ignored and that serious prejudice likely occurred. There are some contexts in which the risk that the jury will not or cannot follow instructions is so great, and the consequence of failure so vital to the defendant that the practical and human limitations of the jury system cannot be ignored. The trial court advised jurors not to make a propensity inference based upon evidence concerning guns allegedly recovered at the Flying W Farms, but it did not offer such an instruction as to the numerous irrelevant shell casings collected from there or at the home on Peterson Road, nor did it instruct jurors what kind of inferences they could make using this evidence. With jurors awash in a sea of other information for months, the practical limitations on a single instruction given on the 20th day of a trial twice that long could not be clearer. The state's theory of an ongoing criminal conspiracy to manipulate and control women was an obvious propensity and character theme. The state's trial presentation was rife with other evidence of George's morally questionable conduct and prior crimes. Although she had no knowledge about the Roden murders, George's ex-wife, Tabitha Claytor, was permitted to describe her relationship and divorce from him, numerous crimes committed by him and his family, and instances in which she portrayed him or his family as doing her wrong. Jake and Angela implicated George in a wide variety of criminal acts and other moral wrongs, some relating to Tabitha that had nothing to do with the murders. The state wanted to use George's custody battle with Tabitha and prior crimes committed alongside his family as evidence of a common scheme or plan, proving he was in on the plot to take Jake and Hannah Mae's daughter away. The entire theory of the state's case is this family functions as a unit, commits crimes as a unit, in particular, threatens the females that come into their midst as a unit, and that's exactly what we have here. George's attorneys say this was a plan to use this as character and propensity theme generalized to the family group. The state's efforts went off the rails because identity was not an issue. There was no signature, fingerprint-like characteristic common to both the Roden killings and prior conduct George engaged in, and the earlier crimes were not part of the same grand design by the defendant. Everyone knew who George was, so they did not need to identify him through his unique conduct. Jake and Angela weakly implicated him in the charged crimes independently from his prior bad acts and crimes. And unlike Jake, George did not kill his former romantic partner. With these differences, proof George did wrong in the past was no different than proof that the accused has a propensity for committing that type of crime. While the state will point to cautionary instructions on this issue too, there is little reason to believe jurors would have understood them when evaluating other acts' evidence. Permitting jurors to consider motive, identity, or common plan or scheme made no sense in this case. And jurors were not told how those factors were any different than the prohibited purpose of providing the character of the defendant or any member of the defendant's family in order to show that the defendant or another family member of his acted in conformity with that character. Weeks after this instruction, jurors would have been focused on the state's closing argument, which postured that George and his family had a way of treating women and were willing to resort to crimes if the women didn't cooperate. The state asked jurors to consider how controlling they were as a group, especially the subset of the 3 that lived on Peterson Road in regards to their girlfriends, wives, mother of their children, and how obsessed they were about gaining custody of their children. They quote the state from the trial, saying these issues with the women and children in their lives should never have led to such a drastic result, but it did. And again, I think you got a glimpse of when both Jake and Angela testified, somewhat more, I think, with Angela, but how their minds worked when dealing with the women who gave them children, and especially when they lost control of those women. The state's case was about who George and his family were the whole time. This court should reject this use of 404B evidence by reversing and remanding with instructions to focus the trial proceedings on probative evidence that does not call so strongly for a conviction based on propensity and character. Another point they make, the trial court erred and denied George the right to due process by permitting Jake and Angela to testify under their coercive plea deals. Jake and Angela's plea deals giving the state sole and complete authority to determine whether their testimony was true. They were not free to tell their own truth. They were coerced into providing the state's truth, whatever they thought that was. When a plea agreement drafted in such a manner that the prosecution seemingly had unilateral authority to determine when and if appellant's cooperation was sufficient, it is an illusionary inducement that does not comport with due process. Jake and Angela's deals also required them to maintain their value as a witness against George. With that advisement, it would not have been hard for them to figure out on their own how to steer their testimony away from reality and towards a conviction. The value of a state witness is to acquire a conviction, and making an agreement to testify contingent on maintaining that value is nothing more than an invitation to perjury, having no place in our constitutional system of justice. Jake and Angela's plea agreements also threatened to reinstate death for Jake, George, Billy, and Angela if the state concluded for itself that any of their testimony was false. As George explained to the trial court, the plea deals are therefore similar to the ancient common law practice of approvement. A defendant would be offered an opportunity to implicate an accomplice for not only his crime, but for all other bad acts by the accomplice. If the defendant succeeded at convicting a co-defendant, he would be pardoned. If he was unsuccessful, he would be put to death. This practice was too conducive to perjury for the law to tolerate in the 17th century. Jake and Angela's deals are actually far worse, as it is the state deciding whether to let them off the death penalty rather than the jurors. That is all the more reason their testimony should not have been permitted. This court should reverse and remand with instructions to provide a fair trial, particularly excluding the testimony of Jake and Angela. Another point, the trial court erred by quashing George's subpoenas for Jake's medical records and interview notes prepared and held by his attorneys without holding an in-camera hearing. It says the trial court must hold an evidentiary hearing before deciding whether a subpoena should be quashed. If a trial court fails to hold a hearing and elicit evidence from the subpoena's proponent about the relevancy of the materials to be produced, the trial court errs in granting the motion to quash. The trial court was required to hold a hearing or examine the materials George demanded from the state and Jake's lawyers before rejecting his requests and subpoenas for them. The trial court erred as a matter of law by denying George's efforts to acquire evidence of Jake's statements to his physicians and his attorneys without at least holding a hearing or in-camera review of those materials. Without knowing what responsive materials even existed, there could be no lawful order cloaking those materials in the secrecy of attorney-client privilege or the work product doctrine. After Jake pled guilty, George issued subpoenas to Jake's attorney seeking any medical records or mental health records that they might possess. Jake moved to quash these subpoenas on the basis of work product privilege, claiming any such records were prepared in anticipation of litigation. George opposed that motion, explaining that such records are relevant to impeach Jake's credibility and asking the court to mandate a private log or engage in an in-camera review to determine whether the work product protection would apply. At the state's request, Jake also vouched for the truthfulness of his original confession to his attorneys. That occurred before his plea deal. George understandably issued subpoenas to Jake's lawyers again, this time asking for the notes of any conversations with Jake regarding his confession. He asserted that Jake had waived any attorney client privilege over that communication by discussing it in front of the jury in response to the state's questions, quashed the subpoena, and denied George's request to have the attorney notes placed under seal for appellate purposes. Simply put, the trial court could not have extended the attorney client privilege and work product protections to these materials without seeing them, nor could it have ruled on the facts dependent question of waiver, which turns on the subject of the allegedly privileged information. It is fairly apparent that the work product doctrine should no longer protect Jake's medical records and mental health records after he pled guilty and had been relieved of the risk of execution. George's defense is a good cause, and he needs every possible evidence that could help him undermine his accusers. So, while the trial court at least erred by failing to engage in an in-camera review of these materials, the basis for shielding at least some of these materials is implausible on its face. This court should reverse and remand for proceedings in which George is completely afforded his right to compulsory process. The next point is saying that the prosecutors engaged in misconduct and rendered the trial unfair during closing arguments by accusing defense counsel of knowing George lied and coaching him to do it. The state crossed the line by arguing that George was lying with the help of his attorneys. It argued the defense counsel made an intentional misstatement because, quote, they know he's guilty. They know he did it, end quote. In response to George's objection, the trial court did not instruct jurors to disregard this unfair attack. It told jurors this was just argument and directed the jury to rely upon its collective memories of the evidence. This did nothing to address the problem. Not long after that, the state argued that George could not be believed because he gave obvious clues he had practiced his answers and that he had been coached on those answers. The obvious implication was that George's attorneys had coached him, knowing full well he planned to lie. The test regarding prosecution misconduct in closing arguments is whether the remarks were improper and, if so, whether they prejudicially affected the substantial rights of the defendant. Without a doubt, arguing that the defense counsel has suborned perjury by manufacturing, conceiving, and fashioning lies to be presented in court is across the line. And when such accusations have been made in the past, a trial court's instruction that arguments of counsel are not to be considered as evidence was insufficient to correct the error. This court should remedy these improper remarks by ordering a new trial for George. The next point, the trial court erred by denying a request for a jury instruction on complicity after the fact. George asked the trial court to instruct jurors that the law in Ohio does not prohibit accessory after the fact. The court denied this request. The court should reverse and remand for a new trial with a fully instructed jury. Being an accessory after the fact is not a crime recognized in Ohio. Helping a murderer after the fact, whether by fabricating an alibi or helping them dispose of the murder weapon, is not punishable on an accomplice theory. Consequently, jurors needed to know that George was not an accomplice to the Roden murders if he had strictly helped with the cover-up. They were entitled to believe all, or some, or none of the testimony admitted at trial. Jurors may have reached a common sense view that George was not originally involved in the murder plot, but decided to assist his family in avoiding responsibility once he found out what they had already done. That would have justified an acquittal for murder, and it was improper to deny jurors an instruction to that effect. The next point, the cumulative impact on numerous errors at trial prejudiced George by swaying the outcome of his trial. It says, finally, if this court concludes that each of the foregoing assigned errors had no independent impact on the jury's verdict, then it should consider whether the cumulative effect of all the errors at trial did, even those that did not fit within the page limits of this brief. A conviction will be reversed if the cumulative effect of all the errors in a trial deprive a defendant of the constitutional right to a fair trial, even though each alleged instance of error may not individually constitute cause for reversal, where the evidence of guilt was not overwhelming and several errors occurred below, thus rendering a trial unfair. A reversal on that basis is warranted. It is not enough to assess the independent prejudicial impact of the various errors. The problem with George's trial conjoined to contort the entire mechanism of justice. The assigned errors flowed together, changing the kind of jury that could be impaneled to decide the case and allowing the state to appeal, particularly to their heartstrings using a great deal of information that had no business being admitted, unduly influencing the testimony of key witnesses for the state, Jake and Angela, and denying George information he would have needed to fully call Jake's story into question. Then, after jurors sat for weeks through trial, the state gave them an easy way out by accusing George's attorneys of knowing he would lie on the stand and coach him. These are not only problems with the trial that combined to make it unfair. Concurrently with this filing, George has asked this court to permit him to submit a supplemental brief asserting other assignments of error that were omitted from this brief purely due to the page limit, not because they lack merit in any way. Those issues also belong in the cumulative error calculus, and this court should consider them. For all the foregoing reasons, this court should reverse the lower court's judgment and remand for a new trial with clear instructions premised on the ruling. So that was the end of their filing. Why was Billy's trial delayed until January of 2025? The hearing for this was back in March. But one member of his defense team was out on maternity leave. Another had knee replacement surgery. Also, the defense said it got 16,000 pages of transcript in January, which the judge said he also had to review. The judge did say this would be the only delay. When this decision was made, two members of the Rhoden family got up and walked out. Gary Rhoden's sister, Wilma McCoy, told the media, "I think this case is being put on the back burner." We'll see if they file that second brief where they lay out more issues, and we'll cover that. But I think there are some interesting arguments made in this, to be honest with you. I'm not sure it's going to rise to the level of a new trial. And as much as I dislike Jake Wagner, I don't think there's any reason to doubt the basic facts of the murders was untrue testimony. I think that Jake had every right to cooperate and to tell the truth. And I have no doubt that George was there with them at every residence, whether he pulled the trigger or not. And Jake's testimony pretty much said that George did not pull the trigger on anybody. If you remember, he was supposed to be the one to shoot Chris Sr., but just couldn't do it in the end. Next week, I'm planning on doing a couple of prison episodes, the prison series I've been doing. It's been a while going through those letters. Also, the FBI files for Brian Laundrie. I'd like to do an episode touching on those. If there are any trials coming up you're interested in that are live streaming, let me know. My plan right now is to cover Alec Baldwin in July. I think that's going to be very interesting. I covered Hannah Gutierrez Reed's trial just a couple of months ago, so I definitely want to follow up and cover Baldwin's trial. And then in September, definitely, I'm going to be all over Donna Adelson, giving daily recaps of the testimony for those of you that can't watch or don't have the desire to sit through 8 hours of court a day. But that's it for today. I hope you guys have a good rest of your weekend. We will see you soon.